Yes, Nevada Legal Services, LLC, America's Partner for Equal Justice. Always on the front lines of emerging issues.
Well, welcome to this edition of Thursdays Live with NLS Now. Of course, I am Rhea Gertken, currently stationed in our Reno office and joined again by David Olshan. Hi, David.
Yes, it's David Olshan.
And we are going to be revisiting the end of the moratorium today. We've tried to present this numerous times. And of course, each time so far, the moratorium has basically been extended. Directive 43 was the last moratorium extension. And David, is there any, I guess, indication that it will be extended again, or is this pretty much it?
Look, I've been wrong so many times. I don't want to predict, but $1 billion in casino earnings in April. I think the direction for politicians and everyone is to assume this COVID crisis is over. And until we have a great sort of uptick in cases, we're going to continue on that path. So I wouldn't see this continued. I wouldn't see the moratorium continued, especially when so many preparations have been made to sort of for the soft landing in June with the CDC moratorium.
Right, and we'll kind of get into what that all means. So we'll go ahead and get started. So as we've been talking about, Directive 43, the Nevada moratorium ends on May 31st, which is Monday. So as of June 1st, the only moratorium that would still be in place would be the CDC moratorium. So one of the things that Directive 43 did was it does prohibit landlords from issuing notices. So up until Monday, if you get a non-payment of rent notice, or if you qualify under Directive 43 and receive a no cause notice, you still are protected. Your landlord should not have issued you that eviction notice. So keep that in mind. Until Monday, if you get a notice, you can still issue the declaration under Directive 43 to protect yourself until essentially Tuesday. If you do, and we're going to talk a little bit about if you already went through the process, maybe you did go to court, you filed with court, and there are different various things the courts were doing with the evictions. We'll talk about sort of what that means. But just remember, if you want to claim the protection until Monday, it's not automatic. You do have to issue that declaration to your landlord. Okay, but as of Tuesday, June 1st, the only moratorium that will still be in effect is the CDC moratorium. And David, any updates on the federal lawsuit regarding the CDC moratorium?
Well, I mean, the common sort of view is that there is a stay. The DC circuit, the DC district court did issue a stay. So it could go to the DC circuit or it could go to the Supreme Court. But why would any court sort of go through the trouble of assessing this when it ends at the end of June, when it ends in sort of less than a month? The feeling is the stay will be there and the CDC moratorium will still be there at the end of June, and it will protect you from non-payment eviction. So it would be very odd for a court to say, yeah, I'm going to do work when I don't really have to, and I'm going to get right into a hot button political issue when there's absolutely no reason for me to do that, because you can easily see how, you know, with the summer coming on, people going on vacation, etc. Why would anyone go out of their way to decide this when they really didn't have to?
Right. So as far as we know, the CDC moratorium is still good through June 30th, and that's likely also probably it for further moratoriums.
Right. And the other thing is, if it does change and it is ruled unconstitutional or struck down, you will hear about it. So I think most people watching us, most people looking at this later, can assume that that CDC moratorium is still good, is still valid, because you haven't heard anything.
And of course, same standards apply as it has always been. You do need to be a covered person. You also need to have submitted a declaration to your landlord. Again, it's not automatic. You do have to submit that declaration to your landlord. If you've already done so, you're still covered. And if you haven't, there is a new form that you can get on the CDC's website. Again, it does protect against non-payment of rent and no cause evictions, but courts in Nevada have wrongly interpreted that the CD moratorium does not apply to no cause evictions. One thing that is true that's in the guidance regarding the CDC moratorium is that it doesn't prevent your landlord from actually issuing the notice in the same way that the Nevada moratorium does. So even if your landlord issues you a no cause notice on June 1st, it technically will not expire until June 30th. Therefore, it is likely going to be sort of a valid notice for any eviction actions after July 1st. So we do want people to be aware that receiving a no cause notice as of June 1st is likely going to be kind of okay. Now, the same thing doesn't apply for non-payment of rent notices. Those are 7-day notices. That should be stayed until July 1st. But remember, it's only a stay of the eviction. So keep in mind that if you owe rent, you still want to be requesting mediation, applying for CHAP rental assistance, whatever you can do, because that rent is still going to be owed.
Right. I mean, if there's any takeaway from this session, it's that you will be protected from non-payment evictions until the end of June. And, a landlord can say, well, the Nevada moratorium has ended, I can evict you. No, that's not true.
But do remember, you need to still submit the declaration to your landlord to receive the CDC moratorium protections if you haven't already done so. Okay. So if you received a non-payment of rent notice and that notice was stayed, I would hope that that stay was through June 30th, which is the operative time frame for the CDC declaration. So what happens on July 1st? You kind of need to call the court to figure that out, because if the eviction was stayed, it is possible that your landlord could simply call the court on July 1st and get a lockout order. If some courts, though, were administratively closing these cases and dismissing the evictions, if that's the case, your landlord would need to issue you a new eviction notice. Again, with the Nevada moratorium, there is an argument the landlord should never have issued you the notice in the first place. So it is possible that your eviction was dismissed and not stayed. Unfortunately, some courts, like I believe the Sparks Justice Court, was actually also, just entering stays on these evictions pursuant to the CDC moratorium, because remember, that doesn't prohibit your landlord from issuing you an eviction notice. So it really is imperative that if you've, gone through any sort of court process, if there was a potential eviction that was heard or stayed, or you had mediation, please contact the court to see what the status of your eviction is and what might need to happen after July 1st. In Las Vegas Justice Court, I believe there was an administrative order, David, you can potentially talk about this more, that does require landlords to file a motion to have the eviction order reissued after July 1st, and they only have 30 days to do so.
Right, but every other notice expired. So if it's 30 days or older, it expired and the landlord has to issue a new notice.
Right. It is probably most likely in most courts that the landlord may just have to issue a new notice.
Right.
But again, as of June 1st, that could be a 30-day no cause notice. As of July 1st, that can be any other notice that the landlord wants to issue. Please also, sorry, go ahead.
No, it's really complicated now, and unnecessarily so. And it relates to the patchwork between federal and state law and local court rules of the court. So, again, if you get an eviction notice and you don't know what to do, you should contact us. We probably can at least instruct you as to what you can do to try to avoid the eviction.
Right. But do also please remember, don't ignore any notices that you get though either, and just assume that everything's going to be good. If you do get a 7-day non-payment of rent notice, or you get a 5-day unlawful detainer notice, you do need to file a tenant's affidavit with the court to contest that notice. In Nevada, please remember, the landlord does not have to file anything in court for the eviction notice to be valid. The tenant is required to file a tenant's affidavit to contest the eviction once you get the eviction notice. So keep in mind that don't ignore any notices though. Do raise your moratorium related defense in the tenant's affidavit.
There may be people who can't plan for this. There's nowhere for them to go. There's no relatives or friends that they can stay with. But the thing that you have to realize is it doesn't necessarily mean the eviction isn't going to happen. So at a minimum, what you should do to prepare is to collect your important things, your keys, your credit cards, whatever, put those in a place where you can just grab them and leave if the constable or the sheriff does knock on you.
All right, as we said, and unless the court has actually stayed the eviction to a date certain, such as June 1st or July 1st, your landlord will have to issue you a new notice to evict you. So that basically just starts the process all over again. And just remember, you do need to respond to those notices. Any repayment agreements that you entered into are binding. So do remember that those are still in effect. And the mediation program is still in place until June 30th as well. That does only apply to non-payment of rent notices, but you still can request mediation if you receive a non-payment of rent notice until the end of June as well. David, do you want to go through the mediation program?
Well, the mediation program, as you indicated, is in effect until the end of June. Frankly, it should be a lot longer, but anyway, if you do get a 7-day pay rent or quit, you can request mediation. I think one of the things we sort of bemoan is that the mediation is funded under the CARES Act, so you have to have some connection to the COVID pandemic, but people usually do have that, so they can request mediation. And the beautiful thing about mediation is it does give you extra time while the court and the mediator prepares, and you have this mediation and you discuss whether a payment plan will work, whether you can pay the landlord back over time. And also, if you're applying for rent assistance, it will help expedite your request for rent assistance. So that may actually save you, at least in the short term. And that's another reason to file for mediation. You get extra time and you may get your rent assistance sooner than if you just go forward with the 7-day and file an affidavit and try to get a hearing in court.
Right, that is true. As far as I know, both in Reno and Las Vegas, and even in Las Vegas, I believe there's also a new program where they are trying to expedite rental assistance applications for people who are facing eviction. So keep that in mind, that if your rental assistance application is still pending and you get an eviction notice, there may be somebody that you can reach out to at the court or the county to try to expedite that.
It's very frustrating. This whole process is frustrating. But Clark County has $160 million to disperse to people. So if people get evicted and don't avail themselves of this money, it's really a sad sort of state of affairs. This money is available. It should save you. It should go to the landlord who's complaining, oh, the moratorium, I'm going broke. Well, here's $160 million that could help you. So, as a public service, you should apply for that rent assistance because it's there, it's available. And if it stays there and it isn't spent, it'll probably go to tear up the roads or, build a new football stadium for the Raiders if the other one isn't good enough.
So yeah, I guess the bottom line is apply for rental assistance, request mediation, do whatever you can to try to protect yourself from eviction for as long as possible.
And you can't buy a stadium for $160 million, so it's good. Sorry.
It was a good try. And then just remember with mediation, make sure if you enter into an agreement to repay your landlord that you actually can do it. Do not just agree thinking that you have to avoid the eviction, because you are bound by that agreement and you will be evicted if you can't fulfill the terms. So just keep that in mind. If you're doing mediation, make sure any agreement you sign is reasonable for you to be able to follow through with. All right, now finally is something else that has recently happened in the Nevada State Legislature, AB 486. David, do you want to go through the particulars?
Sure. I mean, it relates to the $160 million in the money under the CARES Act to help people for rent assistance. And Governor Sisolak mentioned it when he extended the moratorium, that the new eviction notices have to have instructions for tenants to apply for rent assistance. And AB 486 kind of makes that a law, that if you do apply for rent assistance, that's going to help you if the landlord rejects the rent assistance and goes forward with the eviction. It basically allows you a defense. And if a judge recognizes that you won't be evicted if you go for rent assistance and your application is pending or the landlord refuses it. So it's really, really, that's why I said before, go for that rent assistance, because this isn't law yet. AB 486 isn't law yet, but if it does become law, not only will you get the money to pay for your rent and eliminate that charge, but you'll have a defense. You'll have a defense to the eviction, so you can't be evicted, and it's really helpful. The problem is the apartment association and the realtors were against AB 486, so it's, you know, it's under discussion, but there's only a few days left in the legislature, so we'll see what happens. But this could be very helpful, because one of the things that we're worried about is somebody gets evicted while they're going for rent assistance, and AB 486 will cure that. Oh, one other thing, if you just go back, they made this effective July 1st. So it's like, I don't know why they made it effective July 1st. It should be effective immediately upon signature by the governor. And I think that's one of the amendments they were talking about. But that's kind of, you know, this is sort of a last minute thing. It's very helpful, but there still are some flaws. And we'll see, we'll keep you informed, because like I said, there's just a few days left in the legislature.
But I guess the bottom line is apply for rental assistance, and hopefully that will be able to help you at least stop an eviction for non-payment of rent right now or after June 30th.
And look, 7 days, just people should note that. I mean, we used to have a 5-day notice, so now we have 2 extra days. But 7 days is not a lot of time for you to figure out what you're going to do. And so if you have to pack your things, if you have to move, 7 days does not give you enough time. So it's like some people have gone months or perhaps a year or more not paying the rent, but at some point that rent has to be paid. And that's kind of what we're saying. You need to prepare for that, because the end is near.
Right. And if you do receive a 7-day pay rent or quit notice, you do have it is 7 judicial days. So that does not count court holidays and weekends, or any, you know, days the court is officially closed. But you do have those 7 days to obviously pay the rent or move out. You can contest the eviction by filing a tenant's affidavit, which we mentioned earlier, and request mediation in that tenant's affidavit. You know, if your landlord has refused rental assistance, even if for it AB 46 isn't in effect yet, I mean, I would still allege that in your tenant's affidavit. If your rental assistance is still pending, I would allege that in your tenant's affidavit as well. Again, you know, request mediation in the tenant's affidavit. That, you know, may delay things a little bit until you can have your mediation appointment. And then if the mediation fails, you still will get a hearing. Every tenant that files a tenant's affidavit should get a hearing before they are evicted. So keep that in mind. Any hearings that you have, do not miss them. Please show up for them so that you can try to get a delay, get the judge to help you work something out with your landlord, whatever it is to stop the eviction. But the tenant, it is on the tenant to file the tenant's affidavit and basically, you know, assert your rights to any defenses that you have to the eviction.
And we know from experience too, like if you do get a 7-day and request a hearing, even though you owe the rent, even though you really don't have a justification, sometimes the landlord doesn't follow up. So, you know, at least for a few weeks, you're safe because the eviction is denied and the landlord has to start all over again.
All right, so let's say you didn't file a tenant's affidavit, or you went to your hearing and still the judge ordered the eviction. What are some things that you can do? Well, if you didn't file a tenant's affidavit or you missed your hearing, you can file a motion to stay or vacate the eviction. This does need to be filed essentially before you are evicted in order to keep you in the unit. And if you file it, you do need to file that motion to stay along with it. In order to vacate an eviction, you do need to have a legal basis to do so. So make sure that, you know, you're alleging what your legal defense is and the reasons why you either didn't file your tenant's affidavit or didn't show up for your hearing. You can just request a stay if you don't have a legal defense to the eviction, but that stay under NRS 70.010 might only allow you 10 extra days. All right. If you did go to your hearing and were evicted, you can file an appeal. If you post a $250 stay bond, that would allow you to stay in the unit pending the appeal. Of course, if you do something else to violate your lease or you don't pay rent for the next month, your landlord can issue you a new eviction notice and can evict you on new grounds. But the eviction order that was entered would be stayed with the $250 bond and your notice of appeal filed before the lockout. And then finally, I did not make the correction, David. I apologize
Yeah,
to
that's
the
okay.
bankruptcy filing fee. David caught the mistake. It is $338 to file a bankruptcy. But if you file a Chapter 7, an automatic stay does go into effect, and it will stop the proceedings for a short period of time. But if you are behind in rent, your landlord probably will request to lift the stay. But you know, that can take a couple of weeks to get through the court process.
Right, and that's like a last resort, and that's if you have no options, you just want a little bit extra time to move out. Yeah, I would, consider the bankruptcy because there is an automatic stay. And if you get a fee waiver, then it's not going to cost you anything. But in effect, you're abusing the bankruptcy system, you're abusing the law. But I realize that, people who are in desperate situations do things that they have to do to protect themselves and their families.
And for the motion to stay or vacate the eviction, we do have forms on our website. So you can utilize those to assist you if you live outside of Clark County. I would imagine in Clark County, the Civil Law Self-Help Center probably has forms for that. And then finally, just a reminder, we've talked a lot about rental assistance. I just wanted to throw up all of the resources to try to get rental assistance in Nevada. Again, just apply for rental assistance if you haven't done so already. But that will conclude this presentation. If you have any questions, please feel free to put them in the comment for the live stream, and we will try to answer them. We'll stay on for a couple minutes if you guys have any questions. So any final thoughts, David?
No, just I doubt anything new is going to be created in Carson City. There won't be any new bills, but AB 486 will be decided. Hopefully it will be signed by the governor and passed, and you will have a defense if you go for rent assistance and the landlord doesn't participate. I think that's really a problem in a lot of these situations. We had some funds here available for rent assistance, and we found, that landlords did take a while, didn't want to do the W-9 form. With AB 486, then, that's all you need. If a landlord, if you offer the landlord to, if you offer rent assistance to the landlord and the landlord refuses, that would be a defense to the eviction. That's going to be very helpful.
All right. Well, thank you guys for joining us for another Thursday Live with NLS Now. We will be back in 2 weeks for our next edition. I think that is June 10th. Again, please feel free to call us, visit our website. If you have received an eviction notice and need assistance with an eviction, we are certainly willing to see if we can help you. Thank you, David.
Thank you, Ray.
And we will see you later.
Do